suppress hearing, this would be that group. So thank you very much for your patience and your understanding. Do we have a court reporter?
We did not request one, Your Honor.
Okay, so that means we don't. So let me start with a couple things. So one, I have read all of your briefing. I do want to make, I mean, there was a prior recusal. I don't know what the basis was for that recusal. I don't know that it probably doesn't even merit being said, but obviously I have a close working relationship as a judge with Miss Ali and with the Georgia Public Defender Council. I don't think that is any basis for me to be partial or biased in any way, but to the extent it is best practice to just say it on the record and make sure we're all on the same page with that issue. And beyond that, here's what I typically do with these motions is I start with what I think I understand, having read your briefs. And so that way you can either educate me further if I don't know something I should know, or you can correct me if I say something that's wrong. But I find it expedites the process so that you don't feel like you have to educate me more than necessary since I've already read your briefs. So what I understand is that the particular statute that we are dealing with, I mean, all of this really comes down to what is a list. And my understanding is that the statute at issue provides, and I had it pulled up previously, but I've been in such a rush this morning that I don't have it right in front of me. But that the statute provides that the assigned counsel for the circuit will provide a list, or excuse me, will provide not more than 5 nominees to the Public Defender Council, and the Public Defender Council will appoint someone from the list of nominees. I believe those are the important phrases that are in that statute. And from that, what we get is this fundamental dispute about whether or not a list is one name, because the functional application of whether a list is one name or not one name is that if a list is one name, then the local appointed counsel has a great deal of authority and discretion over who is appointed as the public defender for that circuit. Whereas if a list is actually required and one is not provided, which is what I understand to be the Public Defender Council's argument, which is one name is not a list, and therefore no list was ever provided, and therefore, pursuant to other parts of the statute, the Georgia Public Defender Council was authorized to appoint the person that it chose to appoint rather than the name that was recommended by the circuit panel. So that's what I understand. I am also familiar with the case law that both parties have cited, specifically discussing the statutory interpretation rules of the plural and includes the singular, and the singular includes the plural. And with that, what I will do then is it is technically a motion to dismiss by the Public Defender Council of the circuit panel's motion or entire pleading for either mandamus or TRO or some relief associated with either or both prohibiting the person who was chosen by the Public Defender Council or seating the person who was nominated by the panel. And with that, I think, Mr. Smith, that is where I hand it over to you and ask you to take over from there and tell me what your client's position is regarding dismissal.
Thank you, Your Honor. You've taken about 90% of what I was going to say away, so thank you for that.
Sorry.
No, that's great. I think it's clear, Judge, it's our position that it's clear that when you look at the statutory interpretation statute 1-3-1, it's clear that the intention of the General Assembly is very important to that statute. What was the law supposed to do? And I think in this case, it's very clear, and Your Honor, you've already touched on it, that the council Director Ali has full authority to hire and to fire, and the supervisory panel has none. They work as a local group because they know the local politics and they're able to uh, ascertain certain things that maybe the state agency could not. So I think that if you interpret the list as one, and again, you touched on it, you give carte blanche to all the uh, circuits, all the judicial circuits, to have their own person installed as the public defender, and that's just not what the General Assembly was thinking when they drafted this, and I think
Well,
that's clear by the statute.
but don't I have
Uh,
to read more words into the statute to get there, right? Because the legislature made a point of saying not more than five. It could have said more than one, but not more than five. And it didn't. It just said not more than five. And one is not more than five.
that's true, Your Honor, but if that were the case, then why not just give authority to the panel, the supervisory panel, to appoint who they want to appoint? It truncates the power of the council totally. And I just don't think that was the intention. And again, list, I think in statutory interpretation, you take list at its common meaning. It is not a term of art. And if you go, I think you can take judicial notice of the online dictionary. If you go to Merriam-Webster and type in list, it says a series of numbers or names. So it's a list is more than one. It's inherent in the language. They did not have to put in there that it's more than one because it's already inherent in the definition of list.
So
Um,
are we overly technically focusing on the word list, right? When the language itself just says not more than five. And then I mean, really the only place where list and this goes back to your point about whether they have discretion or not, right? And that is clearly, I think, doesn't the statute intend to imbue some discretion to the circuit panel because the state defender is required to choose from the list that's given to them. Now, whether a list is one or more, but is required to choose from that list, right?
Absolutely. That is absolutely true. But again, I don't want to belabor it. They're there because they know who's on the ground and who would be best suited for that position. But they have to give the director an option. They cannot just say, John Smith is our pick. And so John Smith's going to be the pick. So, and I think in further support of that, if you look at subsection D of 171220, the public defender or the panel has the ability
Right, to review once a year,
to
right?
review and to, by vote, say to the director, this person's not doing their job. They need to be removed. So they do have that power. That's true. But the director in every single part of that statute shall have the ability, shall be able to hire and to fire. And I think it's clear that that has to rest solely with the council because I can't believe if this were ruled the other way that I'm afraid you would find many of the other circuits saying, okay, well we got this, we can put in whoever we want, and that's just counterproductive to what I think the essence of the statute is.
Well, as a practical matter, let's play out that 17, I think it 220 D versus E?
Uh, yeah, it's 17, 12, 20 D is
1220,
what I was
thank
referring
you.
to before. That's the
So
main statute.
as a practical matter, let's play out the application of 17 12 20 D, right? So if the panel has the authority to essentially either remove or cause to be removed the person who is sitting as the public defender for the circuit, then couldn't they just say, Miss Ali says, well, you didn't give me a list. You only gave me one name. So I'm appointing this person. And then they say, okay, subsection 20D, we remove that person. And and then they do it again and again and again. I mean, like, what is the practical effect, if not to give a great deal of discretion to the panel if they can summarily remove or cause to be removed in subsection D, and if the director is required to choose from their list in subsection E.
Well, I would argue that the characterization that they have the power, the panel has the power to do that is not completely accurate.
Okay.
I think they have the power to petition the director, and then the director has full power to do what the director wants to do. So I think I'm arguing there's a difference there. Um, the I do see your point that this could just go on ad infinitum, but this is the way it's been done. It's my understanding it's been done since day one, that there's always been these judicial circuits that have provided lists, two or more people, multiple people, and then the director decides. But the director also has power within the statute to appoint an interim circuit public defender. So our argument, and you touched on it, Judge, that since she did not get an appropriate list, she has the power to appoint an interim circuit public defender. Now, she did appoint an interim circuit public defender, and I want to say that is to Director Ali's credit that there was no lapse in service to the people of Okmulgee Circuit. There's always been somebody there. So if the panel doesn't like that person now, and they've been there for quite some time, so if the panel doesn't like that person, why hasn't the panel, as far as I know, the panel has not made some kind, used their powers under D to say this person needs to go. So I think that in order, if you're going to say that they can do that or issue some injunctive relief, I just think that is going to be completely disruptive to the flow of work and to the county itself, and that trickles down to the indigent folks themselves. And I just
What?
don't think that's a slope to go down.
Well, don't get me wrong, it's a slippery slope, and it does concern me greatly that anyone would be denied the timely right to be represented during their criminal proceedings. Couple of questions. Number one, in terms of a remedy, right? Isn't that though why they asked for mandamus, right? Which is that if they persuade the court that the director is required, that shall means shall and doesn't mean may, right? That the director is required to choose the circuit public defender from the list of nominees that they submitted, then isn't if that is in fact a clear legal duty, then wouldn't mandamus lie to require Miss Ali to seat the person whose name was given to them?
Your Honor, I think that goes back to how you define list.
Mhm.
I think that if you define list as one, I think there's some substance to what you said. I think if you define list as not just one, I think then that mandamus does not lie because they have an avenue through D to do something. So I argued I think that mandamus would not lie.
And forgive me, Mr.
It,
Smith, but that reminded me of what my second question was, which
uh-oh, yes,
is
Your Honor.
you have mentioned that they had subsection D, that they had a procedure they could have endeavored to use in subsection D to seek removal because I don't want to go too far down into the weeds of the alleged facts because I don't know anything about them other than what's alleged, but there has been some allegation that the person who is currently appointed by the director as the interim circuit defender has been held in contempt for like lack of being ready. And don't get me wrong, I'm in Fulton County where we have a lot more resources and people are still stretched thin. And I understand the limitations that all these courts and all these legal professionals are facing. So I don't want to mean that I accept that characterization at face value or that it's even a direct reflection on the interim appointed defender. But it does beg the question, that was a long way of getting to it, which is the argument I understand from the panel, the circuit panel, is that they have invoked subsection D and that by sending letters. And I think I understand the director's argument to be that's not sufficient or no, they haven't. Can you address that for me a little bit about whether you believe they've invoked D or not invoked D?
Try, yes, ma'am. What I think plays into this is a couple things. One is I think it was on March 6th is when the panel first sent their list of one. And then I think it was clear that that was not sufficient for Director Ali. Director Ali made that apparent to them in a letter, at least a letter of March 20th. Now, these are all exhibits to the petition, Your Honor, what I'm referring to. They
Right.
are heavily redacted. I have unredacted versions, and there's some points in there that might be salient, but they are redacted in the original petition as filed. But I think that they tried 4 times to push this through. They were not trying to they were just trying to impose their will upon the council by saying this is our nominee. And the director said, no, you did not follow proper procedure. They were put on notice for that, and they should have at least at that time promulgated a list of at least two. So put their man on there, put someone else who would be relevant to that, and that would have solved the entire problem. But they did not do that. Instead, they kept saying, this is our man or woman, and come hell or high water, this we want them in there." But they didn't provide an initial list, and that's what Director Ali is saying. I never got an appropriate list. They could have provided one. They did not. I think that's on them.
So thank you, Mr. Smith. I appreciate that. I know I sort of hijacked your argument, but I did want to give you a chance to. You've been mostly just answered my questions. If you
No, I'm
have
fine.
other
That's
things
fine,
to
Your Honor.
add, otherwise I'm going to call on the panel's attorney, unless you have more. And it's your motion, so I'm going to let you have the last word after I hear from them.
Okay. I don't have anything further, Your Honor. I think you've obviously read the briefs. Everything is in our brief. Um, I think that if you rule in their favor, I just think that will create a, a, a whole lot of a Pandora's box that will be open part way at least, and a lot of things are going to start coming out. And I think the argument we make is sound. The statute may not be written well enough. There maybe need some tweaking to it. I don't know a statute that probably is written well enough,
And I don't think there is one.
but I know you deal with that every day.
Also,
But
my husband used to work for the legislature and help write them, so I know how messy it gets sometimes.
okay, so I think that with that, I'll just remain silent, and I appreciate the last word. So thank you.
Thank you, sir. And Ms. Dowdle, or am I going to hear from? I am going to hear from you,
Oh,
right?
I'm sorry, Judge.
No,
Ms.
Ms.
Dowdle,
Dowdle is with
second
you.
chair with me.
Forgive me.
I probably did not introduce her well enough. She was integral in getting this done, and I want to give her credit for that. So,
Well, and I would like to say thank you very much for the briefing. Um, it was very helpful and very concise on both sides. And I particularly appreciate that there wasn't a lot of mudslinging in terms of whatever there must be a backstory that I don't want to know, and I'm not inviting anybody to tell me about, which has to do with who these people are that have been nominated versus appointed versus difficulties between the panel and the director. I really appreciate that y'all gave me a clean legal issue to focus on and didn't get down into those. It was very helpful.
thank you, Anna. With one quick point, and then you want to get to the other party.
Sure.
I in no way think that the panel is not looking out for the best interest of their constituents. I do believe Director Ali and the council are doing the same thing. So I'm not thinking anything, and I know Director Ali is not nefarious of the panel. I just think they got it wrong. I think they interpreted the law incorrectly, and to interpret it their way would cause additional problems. So I have no problem. Again, I certainly believe the panel is looking out for folks. So I'll be quiet and let you go.
Thank you, Mr. Smith. Who am I going to hear from the panel? Are we going to do rock, paper, scissors, or?
Um, Hello, Your Honor. My name is Tiffany Ellenberg, and I'm going to introduce the panel because we couldn't fit all of our names on our Zoom title. So beside me is Cedric Davis. He practices in Milledgeville.
Okay.
And then on the end is Greenberry Moore. And he practices here locally in Milledgeville and in the Gray area as well. And an interesting side note, Mr. Moore actually served as the circuit public defender several circuit public defenders ago.
Okay.
So he was the first one when this statute first went into place.
Okay.
So, Your Honor, we appreciate your directness in there and focusing on the issue. So if I'm not answering your question, please just stop and interrupt me. I'm gonna try to hit on some of the highlights of what you mentioned. And it's our position that the director just attempted to unilaterally define what an appropriate list is. In her mind, that list is two or more. We apologize for the redaction in the exhibits, but we had to do that for the applicant's privacy in there. But if she didn't feel like our list was appropriate, she could have done exactly what we did, which is file and seek direction from the court and direct us to provide an appropriate list, which she did not do. Instead, and you'll notice this through the exhibits, she chose to ignore the fact that she'd been provided an appropriate, a list or a nominee that had been correctly interviewed by us. But let's play devil's advocate for a minute. What if we only had one applicant? Then how do I come up with a list of more than one?
Well,
And
I don't want to hyper focus on this list thing, right? Because, you know, if I have a list of things I need from the grocery store and the only thing on it is milk, is that still a grocery list, right? And I don't want to get too far into the weeds of that issue, but not for nothing, the statute, other than the word list, does use the plural of nominees twice, right? It says not more than 5 nominees, and it says a list of nominees. And one concern I have from just a pure statutory interpretation context is if I focus on, if I focus on, well, as I questioned Mr. Smith, it says not more than 5, 1 is not more than 5, right? And find that the name that was sent to the director from the panel was sufficient to satisfy subsection 20E. Am I reading out the words list of, right? Because, you know, if Judge Dillard were here, he would tell us that every word has to be given purpose and meaning, and that the state legislature says what it means and means what it says. And it didn't say nominees, which would include the singular. It said list of nominees. And so I guess one concern I have just from a pure statutory interpretation perspective is that if I accept one name as satisfying it, am I reading out of the statute those two words?
respectfully, Your Honor, I think if you interpret it that way, you're reading out the words of not more than 5 people. Respectfully.
Okay.
And
can you address for me, there was in the briefing, there's this discussion back and forth about whether or not 20D was invoked. And I understand the panel's position to be that we did invoke 20D, but the director's position to be no, you did not. And then there's this added piece of my concern that you can just invoke 20D forever and ever and ever, and then keep removing people that the director appoints that isn't your one person. What of that situation? And respectfully, I don't think it's because there were redactions. I think it's how you characterize what you were asking for and what you were saying in the letter versus how the director understood it. Can you address that for me a little bit?
yes, Your Honor, if you specifically look at Exhibit H of our petition, H is in Harry, page 1 of 2, we make reference to the fact that we intend to meet on April the 8th. And that was under the guise of 17-12-20D as in David.
And is that the Zoom meeting that Director Ali did not appear for?
That's correct.
Okay.
Initially, we were gonna have the meeting in person. Subsequent to that, the request was made by and through Natalie Glaser to appear via Zoom due to their request. So we set that up at the same day, same time, and in Exhibit H is in Harry, it is set for April the 8th at 2:00. And that was a review of the current interim chief public defender, because quite candidly, the director had made allegations against him. And so we wanted everything on the table in front of us, the panel, in front of the director, and in front of anybody else who would be pertinent to the fact pattern or to determine what was going on. And so Miss Ali, the director, chose not to appear for that meeting. Everybody else was present, but she was not.
Okay.
And there was no evidence or reason or cause to remove anybody.
What of the concern expressed? So I feel like I have an understand. I mean, I think in a perfect world, what was intended here is some discretion on the part of both the panel and the director, and that the parties would work together in good faith. And so I guess one question I have is, at the time in which the director communicated to you that one name was not a list, why not? I mean, my understanding, you made the point, what if there was only one applicant? But my understanding is that's not the case here, that the panel chose the person that it wanted, whose name it wanted to submit, and submitted it. So when the director said that's not a list, why not just come back and say, okay, well, here's another name, and that makes it a list?
Because we interviewed all three applicants. And based on our interview of those applicants and the layout of our circuit, which is comprised of 8 counties, it's the largest geographical circuit, not largest in population.
Right. I'm actually was born and raised in Middle Georgia, so I'm actually quite familiar geographically with your circuit.
Right.
And I think I know some of the judges in that circuit. So
So you can appreciate how parts of it have more of a city atmosphere, such as Milledgeville, and then you get off in Wilkinson County, and it's far more rural and less economy. So we've got quite the dichotomy that we're dealing with. But we went through the interview process with all 3 applicants. We had a chart, and we all commented and gridded that out and scored those candidates. The other 2 candidates did not score as a valid applicant that we felt like to fill the role sufficiently. I will also say, Your Honor, that Ms. Ali, the director, indicated that while there were 3 applicants, she only interviewed 2 of the 3 applicants. So she unilaterally, summarily just dismissed one of the applicants.
Yeah, he submitted one name on the list.
And she also indicated that she didn't interview the individuals, that her office did. And from the 2 individuals they interviewed, her office submitted to Ms. Ali one name. So isn't the pot calling the kettle black? I mean, isn't that the same fact pattern? If you only have 1 applicant, you could submit 1 name. If you only have 2 applicants, in the argument becomes we must have a list. If you only have 2 applicants and one's fully qualified and one's completely unqualified, does that mean we automatically submit 2 names? Everybody gets a sticker for participation? That's the argument they're making. And that's not where we are.
well, but what, I mean, I understand, I think as I understand it, part of Mr. Smith or the director's expressed concern is that you are stripping some of her discretion away by only giving her 1 name. Because the part that I think we can all agree on is the statute shall mean shall, and the statute says she shall choose the person to be appointed from the list of nominees that is provided to her. And part of the director's position is that essentially negates any discretion she has, because she's not given any choice. If you only give her 1 name, then you are effectively, the panel in that circuit is effectively controlling who is named as the defender.
Your Honor, I don't think that was at all the panel's intent, or we wouldn't have taken the time to interview them and categorize them and rank them. So I understand that she feels like her authority was usurped, but candidly and respectfully, the panel is appointed by 3 different entities, as I'm sure Your Honor's already seen in subparagraph A. 1 by the governor, 1 by the chief judge, and 1 by the county commissioners, who have a financial interest in this game, obviously. And so those are 3 different backgrounds, and that's why this panel was formed. But we attempted to meet with Miss Ali multiple times in person as a panel. She didn't want to meet with us in person as a panel or by Zoom as a panel. We actually suggested in writing multiple times to reopen the application process. And maybe we could come up with a list of more than one person. But for reasons that, I mean, I'll be happy to go into those reasons, but I'm not sure I can do that in a public forum.
Right. And I'd rather not, because I don't think this is, I hope the characterization I've heard from both Mr. Smith and you is that while there seems to have been a breakdown in communication, that it is hopefully a breakdown in communication between well-meaning people who are attempting to ensure that a necessary service is being provided in your circuit. And so I don't think that it serves any purpose for us to get down into the weeds of who these individuals are, why they were qualified or not qualified, why they were preferred or not preferred. Let's just, y'all are entitled to decide who you think is a preferred or not preferred based on qualifications. And Miss Ali presumably did the same with the person that she chose, and we will go from there. Go ahead.
But we would respectfully say, Your Honor, she only interviewed 2 of the 3 applicants. Then she couldn't have made an appropriate or accurate determination.
Understood. Okay.
And quite frankly, that act alone seems to indicate a bias and frankly usurping of the responsibility placed in the panel. You know, that the argument of the state a minute ago was, well, the panel can act on subsection D as in David. That's not the way the statute's written. The statute's written so that E as in Edward applies first. So that the applicants are vetted through this panel, who comes from appointed by 3 different resources, and then is submitted to the director. Now, if the director had a reason not to choose the person that we submitted, she should have articulated that with specificity. While she continued to say she had a reason, and we asked repeatedly for documentation, for facts, specific facts. That's what we were asking for, and she never could provide it. It was interesting that, I don't want to get into the weeds of it. There were several things that transpired during the process that there seemed to be the applicant that Miss Ali ultimately chose had a direct line of communication to the state office.
Your Honor, isn't this going far afield and actually into the weeds? I mean, this is not a motion for summary judgment.
Yeah, no, I agree. It is. And I don't think that, I mean, as I think I've said, and just to make clear, there was clearly a breakdown in communication. And so I assumed, without being educated about it, and I don't want to be educated about it, that there was some sort of breakdown here, because otherwise the answer would have been, you only gave me one name. Yes, but that's because that's the best person. And then y'all would have figured it out. But y'all didn't, because here you are. And I don't know why y'all couldn't figure it out, right? But there's a backstory there that's not relevant to my legal determination here. It might be relevant as the case goes forward, which I will say as a point of transition is really my next question as we sort of wrap things up. And that is this: procedurally, if I deny the motion to dismiss, right? What happens then? Where does this case go procedurally?
Well, I think, Your Honor, at that point, we're going to move to do depositions of the director and other individuals that were involved, so that we can move forward on the request for relief. Because the statute—
And that relief being either injunctive or mandamus relief, correct?
Yes, Your Honor, and unfortunately, due to the circumstances of 2 other judges being involved ahead of this case, or, you know, removing themselves during the process, because there were actually 2 others.
Who else? Yeah, I don't know that I saw. Anyway, go ahead.
There's a a motion filed by the defendants to remove the first judge.
Okay.
And
Oh,
then
that's right. I remember there was, and then that judge voluntarily recused, and then it got assigned somewhere else, and that person recused. I remember now. Okay, thank you. I had not focused on that because my only connection to anyone involved in the case is that obviously I deal with Miss Ali professionally, in terms of securing representation for people in my court as well. So.
Sure, sure. I think all Superior Court judges have the benefit of that wonderful office, so. But to answer your point or question a minute ago, why not submit a second list of names? There was a dialogue between the panel and, the executive director, in which if we did submit a second name, it was not going to be the considered by the director, and the director specifically wanted that third individual that we had ranked at the bottom named,
Understood.
and that she ultimately chose.
Okay. Okay.
Judge, I may be wrong, but I'm not sure that the statements that counsel just made were ever in any pleading
I
or
don't
any
think that they
exhibit.
were, and I'm happy to
So
disregard them.
yes,
I don't believe that they're outcome determinative. And I'd rather stay away from, again, those internal decision-making processes about who was chosen or who was not. As I said, what matters is the panel chose a person, submitted that name to the director, and the director said, that's not a list, and so I'm going to appoint someone else. And that's what happened here. And the relative preferences or qualifications of those individuals is not relevant to my decision-making process. Anything else from the panel?
Your Honor, I would just respectfully refer you to also Exhibit E as in Edward, that's
Mhm.
attached to our original complaint, and that's page 3 of 3. And in that, the director cites reference to 171220 E as in Edward, and
Mhm.
says, because I don't have a list, I'm going to invoke my right under E. And of course, it's our position that we submitted a list of not more than 5 people based upon the interview process. So we have a definite differing opinion of the interpretation of how that procedurally occurs.
Okay. Understood. Thank you very much.
Yeah.
Mr. Smith, I promised that you would have the last word, and so I'm going to let you have it, sir. But right now you're muted.
technology is grand, Your
It
Honor. All
wouldn't be
right.
a Zoom hearing if you didn't have to say that at least one time.
Yeah. Just briefly, Your Honor, kind of the last statement that counsel just made, I found interesting because earlier she said that in the statute, E comes before D. And if E is kind of the controlling provision, then Director Ali did exactly what she had to do by appointing an interim public defender. That is what the statute says she shall do, and she has the authority to do. And then they'll submit a list, and she can pick from the list. Again, I just think she's tried to stay within the confines of the statute. I understand there's some, like Your Honor knows, there's a lot of things going on here that hopefully will get resolved so these folks can work together because they're going to have to. But I think that the other thing, just a point to make, is I am not sure if this moves forward that any relief can be had. And if any relief is given, I think it's going to be so disruptive as to just be the cure is going to be worse than the sickness. So I'll leave it at that, Your Honor. I think our brief speaks for itself. I appreciate your time and thank you.
Thank you, Mr. Smith.
Oh,
So I'm not going to rule right now. I think what would be helpful is if I could have proposed orders from the two sides in Word format so that, because I generally am not going to take your order and just say, granted. I'm typically going to use it as a guide to make the ruling that I want to make. The briefing is a great guide, because you have focused on what I think is the important part, because setting aside all of the back issues, ultimately, the question here is whether or not what is the import of the words not more than 5, and a list of nominees. And whether that means one person is sufficient or not. And ultimately, that's what I have to decide like I said, from a very pure statutory interpretation. Now, that's what I have focused on. But at the end of the day, we are here on a motion to dismiss, right? And so I don't actually have to resolve that legal issue. I can, but I don't necessarily have to resolve it to determine that the motion should be dismissed, because there might be a universe in which the panel is entitled to some relief. What I suspect I will find when I get into it is that if one name can be a list, then the question is, what is appropriate relief? And is that a clear legal duty such that it would support a claim of mandamus or otherwise and merit the denial of the motion to dismiss? The reason I say all that is because I try really hard to stay in my lane of not reaching out and grabbing larger legal issues that do not need to be determined for purposes of resolving the current motion to dismiss. And so I say all that to ask you to please keep that framework in mind when you are sending me a proposed order ruling in each of your respective favors, is that it is not my intention to reach out and grab issues that I don't have to reach out and grab. I believe that it is most likely that I do have to resolve that issue, but I think there might be a universe in which I don't resolve that issue, just as there might be a universe in which I resolve that issue in favor of the panel, but then have to look at whether or not they would be entitled to the relief that they're seeking, even if a list is in fact one name. And so that's the part that I will be working through. And it's the holidays, or it's getting into the holidays. I don't want to let this sit too long because it gets stale the longer it sits. Would 10 days, and then I would hopefully try to get you a ruling by the end of the year. Sooner possible, but by the end of the year, definitely. Would that work, Mr. Smith?
10 days is fine, Your Honor.
Okay. Miss Ellen, it's Ellenberg, right?
Yes, Your Honor.
Okay, Miss Ellenberg?
Just as a point of clarification, I think
Yes,
Mr. Smith indicated that he made reference to a interim director, but so that we stay on the same narrowed issue for these proposed orders, I
yes.
want to be sure that we're actually referring to the placement of the permanent.
Right. No, I understand.
Okay.
I appreciate you making the clarification. I'm going to say what I think I understand, and Mr. Smith, you can tell me if I'm wrong, but obviously the larger argument we're having is about the panel's recommendation for a permanent named circuit defender and the director's rejection of that name because it was not a list, and then instead appointment of an interim director because she did not receive a list, or an interim defender, I meant. And that's what I believe, and I appreciate the clarification to make sure we are all on the same page, but that's what I understand it to be.
That's true, Your Honor. I guess I would just make one comment that perhaps some consideration could be given to the fact that this person who's in the PD's seat right now, I don't think there have been any complaints about the job they've done. There may well be, and I guess that's not relevant, but
Okay. Well,
we're
like I said, there is always time for the parties to come together and try to work out their issues, because it doesn't do anybody any good to legislate and litigate when the parties could find a way to work together. But that requires everybody to sit down together and try to work through the issues. And it sounds like maybe there's been some disconnect in that regard. So what
well,
I'm going to do, I would encourage you all to do that on your own, and to see if you can say, hey, Judge, never mind, we got it all worked out. But if you can't, then what I will be looking for is, today is the 2nd of December. I will be looking for proposed orders by the 12th of December, which is 10 days from now. And then I will endeavor to get you a written ruling no later than the 31st of December. Okay. Anything else anybody needs from me, Mr. Smith?
I was just going to say, I've never met Ms. Ellenberg before, but I certainly am agreeable to any type of talk So if I'll send Ms. Ellenberg an email and see if we can do that. If not, I understand, but we're certainly agreeable to doing that. So thank you for bringing that up.
Excellent. Thank you, Mr. Smith. Ms. Ellenberg, anything else from the panel?
No, Your Honor.
Okay, excellent. Well, thank you all very much. And I hope you all have a wonderful holiday. And I will get you a ruling as soon as I get your orders, unless y'all tell me I don't have to. Take care.
Thank you, Judge.
Thanks.